ಹೊಂದಿರತಕ್ಕಂತ ಆಗಲಿ ಅಥವಾ ನಗರದ ವಾಸಿಗಳ ಸ್ವತ್ತಲ್ಲ. ಬದಲಾಗಿ ಸರ್ ಅವರು ಒಂದು ಬಡ ಮನೆತನದಲ್ಲಿ, ಅದು ರೈತರ ಕುಟುಂಬದಲ್ಲಿ ಹುಟ್ಟಿ ಬರಗಾಲ ಬಡತನದಲ್ಲಿ ಬೇಗಿ ಒಂದು IAS ನಲ್ಲಿ ಹೂವಾಗಿ ಅರಳಿ ಅವರ ಸೇವೆ 37 ವರ್ಷ ಸೇವೆಯಲ್ಲಿ ಲಕ್ಷಾಂತರ ಜನರ ಜೀವನದಲ್ಲಿ ಬೆಳಕನ್ನು ನಂದಾದೀಪ ಅಂದ್ರೆ ತಪ್ಪಾಗ್ಲಾರ್ದು. ಸರ್ ಅವರು ಬಹಳ ದೂರದವರಲ್ಲ. ಅವರು ಇಲ್ಲೇ ಅವರಿಗೆ ಮಣ್ಣಿನ ಮಗ ಅಂದ್ರೆ ತಪ್ಪಾಗ್ಲಾರ್ದು. ಇಲ್ಲೇ 25 ಕಿಲೋಮೀಟರ್ ದೂರದಲ್ಲಿರುವ MK ಹುಬ್ಬಳ್ಳಿಯಲ್ಲಿ ಅವರ ಅಜ್ಜ ಅಜ್ಜಿ ಊರಲ್ಲಿ ಜನಿಸಿದವರು. ಸರ್ ಅವರ ಪ್ರಾಥಮಿಕ ಶಿಕ್ಷಣ ತೋರ್ಗಲ್ ಗ್ರಾಮ ರಾಮದುರ್ಗ ತಾಲೂಕಿನಲ್ಲಿ ಆಗಿದ್ದು. ಆಮೇಲೆ ಹೈಸ್ಕೂಲು ರಾಮದುರ್ಗ ತಾಲೂಕಿನಲ್ಲಿ ಆಗಿದೆ. ಮತ್ತು ಸರ್ ಅವರು ಇಲ್ಲೇ KCDಯಲ್ಲಿ ಕ್ರಿಮಿನಾಲಜಿ ಮತ್ತು ಸೈಕಾಲಜಿಯಲ್ಲಿ BA ಮಾಡಿದ್ದಾರೆ. MA ಸೋಷಿಯಲ್ ವರ್ಕ್ ಅಲ್ಲಿ ಟಾಟಾ ಇನ್ಸ್ಟಿಟ್ಯೂಟ್ ಆಫ್ ಸೋಷಿಯಲ್ ಸೈನ್ಸ್ ಬಾಂಬೆ ಇಲ್ಲಿ ಅವರು ಫಸ್ಟ್ ರ್ಯಾಂಕ್ ಅಂಡ್ ಬೆಸ್ಟ್ ಸ್ಟೂಡೆಂಟ್ ಆಗಿ ಹೊರಹೊಮ್ಮಿದ್ದಾರೆ. ಸರ್ ಅವರು ಅವರಿಗೆ ಜ್ಞಾನದ ದಾಹ ಬಹಳ ಇತ್ತು. ಹಾಗಾಗಿ ಕ್ರಿಮಿನಾಲಜಿಯಲ್ಲಿ MS ಮಾಡಿದ್ದಾರೆ ಫ್ಲೋರಿಡಾ ಸ್ಟೇಟ್ ಯೂನಿವರ್ಸಿಟಿಯಿಂದ. ಮತ್ತು ಅದರಲ್ಲಿ ಅವರು 3.9 GPA ಔಟ್ ಆಫ್ 4 ಪಾಯಿಂಟ್ಸ್ ಅಂದ್ರೆ ಅಷ್ಟೊಂದು ಅಂದ್ರೆ ಅದು ನಮಗೂ ಅಷ್ಟು ಸರಿಯಾಗಿ ಹೇಳಕ್ ಬರ್ತಾ ಇಲ್ಲ ಯಾವ ರೀತಿ ಡಾಕ್ಟರ್ ಇದನ್ನ ಅವಾರ್ಡ್ ಮಾಡ್ತಾರೆ ಅಂತ ಹೇಳಿ. ಅಷ್ಟು ಮೆರಿಟೋರಿಯಸ್ ಸ್ಟೂಡೆಂಟ್ ಸರ್ ಅವರು. ಅದೇ ರೀತಿ ಡೆವಲಪ್ಮೆಂಟ್ ಸ್ಟಡೀಸ್ ಅಲ್ಲಿ MSc ಮಾಡಿದ್ದಾರೆ ಇನ್ ದ ಇಯರ್ 94-95. ಅದು ಕೂಡ ಫಸ್ಟ್ ಕ್ಲಾಸ್ ಅಲ್ಲಿ ಪಾಸ್ ಆಗಿದ್ದಾರೆ. ಸರ್ ಅವರು ಡಾಕ್ಟರಲ್ ಸ್ಟಡೀಸ್ ಇನ್ USA ಅಲ್ಲಿ ಕ್ರಿಮಿನಾಲಜಿಯಲ್ಲಿ ಅವರು ತಮ್ಮ ಹೆಚ್ಚಿನ ವಿದ್ಯಾಭ್ಯಾಸವನ್ನು ಮಾಡಿದ್ದಾರೆ. ಇಷ್ಟು ಹೇಳಿದ್ರೆ ಬಹಳ ಇದು ಪೇನ್ ಅಂದ್ರೆ ಇದನ್ನಿಸ್ಬೋದು. ಲೈಕ್ ಫ್ರೀ ಅಂದ್ರೆ ವಾಟ್ ಐ ಟೋಲ್ಡ್ ಫ್ರಮ್ ತೋರ್ವಲ್ ಟು ಫ್ಲೋರಿಡಾ, ಫ್ರಮ್ ತೋರ್ವಲ್ ಟು ಲಂಡನ್. ಸರ್ ಅವರಿಗೆ ಲಾಂಗ್ ಜರ್ನಿ ಏನಿತ್ತು ಅದು ಹೂವಿನ ಹಾಸಿಗೆ ಆಗಿರ್ಲಿಲ್ಲ. ಅವರು ಒಂದು ಬಡ ರೈತ ಕುಟುಂಬದಲ್ಲಿ ಜನಿಸಿದವರು. ಸರ್ ಅವರ ತಾಯಿ ಇವರು 8 ತಿಂಗಳ ಕೂಸಿರುವಾಗಿ ತೀರ್ಕೊಳ್ತಾರೆ. ಅವರ ತಂದೆಯ ಜವಾಬ್ದಾರಿ 6 ವರ್ಷದ ಸಿಸ್ಟರ್ ಇವರನ್ನ ಪಾಲನೆ ಪೋಷಣೆ ಮಾಡೋ ಜೊತೆಗೆ ಆ ಬರಗಾಲ ಮತ್ತು ಬಡತನದಲ್ಲಿ ಎಷ್ಟು ಕಷ್ಟಪಟ್ಟಿದ್ದಾರೆ ತಂದೆರಂದ್ರೆ ನಿಜವಾಗೂ ಬಹಳ ಅದ್ಭುತವಾದದ್ದು. ಅವರು ನಮ್ಗೆ ಧಾರವಾಡದಲ್ಲಿ KCD ಬಹಳ ಹತ್ರ ಕಾಣ್ತದೆ. KCDಯಲ್ಲಿ ಸರ್ ಅವರು ಸ್ಟಡಿ ಮಾಡ್ಲಿಕ್ಕೆ ಅವರ ತಂದೆ ಆಗ 2 ಎಕರೆ ಜಮೀನು ಮಾಡಬೇಕಾಗಿತ್ತು. ಅದು 500 ರೂಪಾಯಿಗೆ 1 ಎಕರೆ ಜಮೀನು, ನೀರಾವರಿ ಜಮೀನು. ಆಮೇಲೆ ಆವಾಗ ಬೆಳ್ಳಿಯ ಬೆಲೆ 12 ರೂಪಾಯಿ, 2-3 kg ಬೆಳ್ಳಿ ಮಾಡ್ತಾರೆ ಅವ್ರ ತಂದೆಯವರು. ಅದೇ ಬಂಗಾರದ ಬೆಲೆ 120 ರೂಪಾಯಿ ತೊಲೆ. ಸಾಕಷ್ಟು ಬಂಗಾರ ಕೂಡ ಮಾಡ್ತಾರೆ, ದನಕರುಗಳನ್ನ ಮಾಡ್ತಾರೆ. ಆದಾಗ್ಯೂ ಕೆಲವೊಮ್ಮೆ ದುಡ್ಡು ಸಾಕದೇ ಇದ್ದಾಗ ಸರ್ ಕಷ್ಟದ ಹಸಿವನ್ನ ಮರೆತು ಜ್ಞಾನದ ದಾಹವನ್ನ ತೀರ್ಸ್ಕೊಳ್ತಾರೆ. ಅವರೆಲ್ಲ ಸ್ಕಾಲರ್ಶಿಪ್ ಮೂಲಕ ಫ್ಲೋರಿಡಾಗೆ ಹೋಗಿ ಅವರು ತಮ್ಮ ಸ್ಟಡಿಯನ್ನ ಮಾಡಿ ವೆನ್ ಹಿ ವಾಸ್ ಜಸ್ಟ್ 27 ಅವರಿಗೆ ಫ್ಲೋರಿಡಾ ಯೂನಿವರ್ಸಿಟಿಯಲ್ಲಿ ಅಸಿಸ್ಟೆಂಟ್ ಪ್ರೊಫೆಸರ್ ಆಗಿ ಜಾಬ್ ಆಫರ್ ಮಾಡ್ತಾರೆ. ಅದೇ ರೀತಿ ಯುನೈಟೆಡ್ ಸ್ಟೇಟ್ಸ್ ಸೋಷಿಯಲ್ ಡಿಫೆನ್ಸ್ ಅಡ್ವೈಸರ್ ಆಗಿ ರೋಮ್ ಅಲ್ಲಿ ಅವರಿಗೆ ಜಾಬ್ ಸಿಗುತ್ತೆ. ಅದೇ ಟೈಮಲ್ಲಿ ಸರ್ ಅವರು ಲಂಡನ್ ಇಂದ ಲಂಡನ್ ಸೆಂಟರ್ IAS ಮಾಡ್ತಾರೆ. ಸೊ ಹೀಗೆ ಅಟ್ ಎ ಟೈಮ್ 3 ಹುದ್ದೆಗಳಿದಾವೆ. ಈ 3 ಹುದ್ದೆಗಳಲ್ಲಿ ಯಾವುದಕ್ಕೆ ಆಯ್ಕೆ ಮಾಡ್ಕೋಬೇಕು ಅನ್ನೋದಕ್ಕೆ ಜಿಜ್ಞಾಸೆಯಲ್ಲಿ 2-3 ತಿಂಗಳು ಅವರು ಹುಚ್ಚರಾಗಿರ್ತಾರೆ. ಕೊನೆಗೆ ಅವರ ಶಿಕ್ಷಕರ ಏನು ವೆನೆನ್ ಪಾಕ್ಸ್ ಅಂತಕ್ಕಂಥ ಪ್ರೊಫೆಸರ್ ಅವರಿಗೆ ಅಡ್ವೈಸ್ ಮಾಡ್ತಾರೆ, ನೋಡಪ್ಪ ಇಷ್ಟೆಲ್ಲ ಜ್ಞಾನಾರ್ಜನೆ ಮಾಡಿ ನೀನ್ ಎಲ್ಲೋ ಪ್ರೊಫೆಸರ್ ಆಗಿ ಟ್ಯಾಕ್ಸ್ ಫ್ರೀ ಇನ್ಕಮ್ ತಗೊಂಡು ನಿನ್ ಲೈಫ್ ಕಂಫರ್ಟ್ ಮಾಡ್ಕೋಬಹುದು, ಬೇಡ ಬಡತನ ಇರ್ತಕ್ಕಂಥ ರಾಷ್ಟ್ರ, ಅಭಿವೃದ್ಧಿ ಆಗ್ತಕ್ಕಂಥ ರಾಷ್ಟ್ರ, ಅಲ್ಲಿ ಹೋಗಿ ನಿನ್ನ ಸೇವೆ ಕೇಳ್ಕೊಂಡಾಗ ಸರ್ ಅವರ ಅದರ ಸಲಹೆಯನ್ನು ಒಪ್ಕೊಂಡು ಅವರು ಸಿವಿಲ್ ಸರ್ವಿಸ್ ಜಾಯ್ನ್ ಆಗಿ ಇಲ್ಲಿ ಸುಮಾರು 32 ವರ್ಷಗಳ ಕಾಲ ಅವರು ಸೇವೆಯನ್ನು ಸಲ್ಲಿಸ್ತಾರೆ. ಸರ್ ಬಗ್ಗೆ ಎಷ್ಟೇ ಹೇಳಿದ್ರು ಕಡಿಮೆನೆ. ಸರ್ ಅವರು 4 ಜಿಲ್ಲೆಗಳಲ್ಲಿ ಜಿಲ್ಲಾಧಿಕಾರಿಯಾಗಿ ಕೆಲಸ ಮಾಡಿದ್ದಾರೆ. ಎಲ್ಲೂ ಹೋದ್ರು ಒಳ್ಳೆ ಹೆಸರನ್ನ ಗಳಿಸಿದ್ರು. ವಿಶೇಷವಾಗಿ ಅವರು ಅಪ್ಪರ್ ಕೃಷ್ಣ ಪ್ರಾಜೆಕ್ಟ್ ಅಲ್ಲಿ ಬಹಳ ಪ್ರೆಸ್ಟೀಜಿಯಸ್ ಪ್ರಾಜೆಕ್ಟ್, 15 ಲಕ್ಷ ಎಕರೆ ಜಮೀನಿಗೆ ನೀರುಣಿಸುವಂತ ಪ್ರಾಜೆಕ್ಟ್ ಅದು. 300 ಮೆಗಾವ್ಯಾಟ್ ವಿದ್ಯುತ್ ಶಕ್ತಿ ಉತ್ಪಾದಿಸುವಂತದ್ದು. ಸುಮಾರು 200 ಹಳ್ಳಿಗಳಷ್ಟು ಡಿಸ್ಪ್ಲೇಸ್ ಮಾಡಬೇಕಾಗಿತ್ತು. ಒಂದು 2 ಲಕ್ಷ ಜನಕ್ಕೆ ಅದು ತೊಂದರೆ ಆಗ್ತಿತ್ತು. ಅಂತದನ್ನ ಬಹಳ ಹೆರ್ಕ್ಯುಲಸ್ ಟಾಸ್ಕ್ ಅನ್ನ ಅವರು ತಮ್ಮ ಏನು ಉಸ್ತುವಾರಿಯಲ್ಲಿ ಸುಮಾರು 11 ವರ್ಷಗಳ ಕಾಲ ಅಪ್ಪರ್ ಕೃಷ್ಣದ ಏನು ಆರ್ಕಿಟೆಕ್ಟ್ ಅಂತ ಹೇಳಿದ್ರೆ ತಪ್ಪಾಗದ, ನಾವೆಲ್ಲ ಓದ್ತಿದ್ವಿ. ಅಂದ್ರೆ ಹೌ ನರ್ಮದಾ ವ್ಯಾಲಿ ಪ್ರಾಜೆಕ್ಟ್ ಫೇಲ್ಡ್ in implementing in a time-bound manner, how the one man, Dr. Jamdar, made success in Upper Krishna project ಅಂತ ಹೇಳಿ ಅವಾಗೆಲ್ಲ ನ್ಯಾಷನಲ್ ಡೈರೀಸ್ ಎಡಿಟೋರಿಯಲ್ ನ ಓದ್ತಿದ್ವಿ. ನಾನು ಕೂಡ ಅಪ್ಪರ್ ಕೃಷ್ಣ ಪ್ರಾಜೆಕ್ಟ್ ಅಲ್ಲಿ ಕೆಲಸ ಮಾಡಿದ್ದೇನೆ. ದಟ್ ಇಸ್ ಆನ್ ಪೋಸ್ಟ್ ಜಾಮದಾರ್ ಎರಾ. ಅಂದ್ರೆ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಹಾವೇರಿಯಿಂದ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿ ಲ್ಯಾಂಡ್ ಅಕ್ವಿಸಿಷನ್ ಆಫೀಸರ್ ಆಗಿ ಅಪ್ಪರ್ ಕೃಷ್ಣ ಪ್ರಾಜೆಕ್ಟ್ ಹೋದಾಗ ನನಗೆ ಕೇಳಿದೆ ಎಲ್ಲಿ ಕಮಿಷನರ್ ಆಫೀಸ್ ಅಂತ ಹೇಳಿ, ಅಥವಾ ಆಯುಕ್ತರು ಪುನರ್ವಸತಿ ಪುನರ್ನಿರ್ಮಾಣ ಎಲ್ಲಿ ಅಂತ ಕೇಳಿದಾಗ ಯಾರು ಹೇಳಿಲ್ಲ. ಅಲ್ಲಿ ಒಬ್ಬ ನಿಂತ ಓಡ್ ಬಂದು ಜಾಮದಾರ್ ಆಫೀಸ್ ಏನ್ ಸರ್ ಅಂತ ಕೇಳಿದ್ರು. ಅಂದ್ರೆ ಆ ವ್ಯಕ್ತಿಯಿಂದ ಆಫೀಸ್ ಅನ್ನ ದುಡಿಸ್ತಾ ಇದ್ರು. ಚಂಡೀಗಢ ಮಾಡೆಲ್ ಅಲ್ಲಿ ನಮ್ಮ ನವನಗರವನ್ನು ಕಟ್ಟಿದ್ದಾರೆ ಬಾಗಲಕೋಟು. ಅದು ಒಮ್ಮೆ ತಾವೆಲ್ಲ ನೋಡಿ. ಜೊತೆಗೆ ನಾವು ಫೀಲ್ಡ್ಗೆಲ್ಲ ಹೋದಾಗ ಸರ್, ಅಲ್ಲಿ ನವಲ್ಗುಂದ ಬೇರೆ ಬೇರೆ ತಾಲೂಕುಗಳಲ್ಲಿ 7-8 ತಾಲೂಕು ಬರ್ತಿದ್ವು. ಹೋದಾಗ ಸ್ವಲ್ಪ ಏನೋ ಸ್ಪಾಟ್ ಇನ್ಫೆಕ್ಷನ್ ಇದ್ದಾಗ ಹೋದಾಗ ಮನೆ ಒಳಗಡೆ ಪಾಪ ಜನ ಬಹಳ ಒಳ್ಳೆ ಜನ ಕರೆದು ನಮ್ಗೆ ಕೆಲಸ ಜೊತೆ ಸ್ವಲ್ಪ ಟೀ ತಿಂಡಿ ಎಲ್ಲ ಕೊಡ್ತಿದ್ರು. ನಾವು ಮನೆಗಳಿಗೆ ಹೋದಾಗ ನೋಡ್ತಿದ್ದು ಅವ್ರ ಮನೆಗಳಲ್ಲಿ ಬಸವಣ್ಣವ್ರ ಫೋಟೋ ಜೊತೆಗೆ ಸಾಹೇಬ್ರ ಫೋಟೋ ಕೂಡ ಇರ್ತಿತ್ತಲ್ಲಿ. ಅಂದ್ರೆ ಸರ್ ಅನ್ನ ಆಂಧ್ರದಲ್ಲಿ ಸೊ ಸರ್ ಬಗ್ಗೆ ಬಹಳಷ್ಟು ಹೇಳ್ತಿದೆ. ನಾನು ಅವರು ಏನು ಈ ಅಪ್ಪರ್ ಕೃಷ್ಣ ಪ್ರಾಜೆಕ್ಟ್ ಸಕ್ಸಸ್ ಮಾಡಿದ್ದು ಒಂದು ಅದ್ಭುತವಾಗಿರ್ತಕ್ಕಂಥ ಕೆಲಸ. ಅವ್ರು ಎಷ್ಟು ಶ್ರಮಜೀವಿ ಅಂದ್ರೆ, ನಮ್ಗೆ ಬೆಳಗ್ಗೆ 10 ಗಂಟೆಗೆ ಬೆಲ್ಲಾದ್ಮೇಲೆ 5 ಗಂಟೆ ಆಗ್ತಿಲ್ಲ, ಸಾಯಂಕಾಲ 7 ಗಂಟೆಗೆ ಮೀಟಿಂಗ್ ಶುರು ಮಾಡಿದ್ರೆ ನೆಕ್ಸ್ಟ್ ಡೇ ಮಾರ್ನಿಂಗ್ 4 o'clock ಮೀಟಿಂಗ್ ಮಾಡ್ತಿದ್ರು ಸರ್ ಅವರು. ಅಷ್ಟೊಂದು ಕ್ರಿಯಾಶೀಲ, ದಕ್ಷ, ಪ್ರಾಮಾಣಿಕ ಅಧಿಕಾರಿ. ಅವರಿಂದ ನಾವು ಕೂಡ ಕಲ್ತಿಲ್ಲಿ ಬಂದಕ್ಕ, ಅಂದ್ರೆ ಅವರಿಂದ ನೋಡಿ ನಾವು ಅಧಿಕಾರಿ ಆದವರು. ನನ್ನ ಒಂದು ಅನುಭವ ಹೇಳ್ಬೇಕಂದ್ರೆ, ಬಹುಶಃ ಅವರು ಜಾಮದಾರ್ ಸರ್ ಅವರು ಶಿವಮೊಗ್ಗದ ಜಿಲ್ಲಾಧಿಕಾರಿಯಾಗಿ ರಿಪಬ್ಲಿಕ್ ಡೇ ಪರೇಡ್ ಅನ್ನ ನೆಹರು ಸ್ಟೇಡಿಯಂ ಅಲ್ಲಿ ಅವರು ಗಾರ್ಡ್ ಆಫ್ ಆನರ್ ತಗೊಳ್ತಾ ಇರೋದು, ಓಪನ್ ವೆಹಿಕಲ್ ಅಲ್ಲಿ ಅವರಿಗೆ ಸಲ್ಯೂಟ್ ಮಾಡ್ತಾ ಇರೋದು, ಆ ಎಲ್ಲ ಅವ್ರೇನು ಒಂದು ಎಫೆಕ್ಟಿವ್ ವೈಬ್ರೆಂಟ್ ಅಡ್ಮಿಷನ್ ಕೊಡ್ತಾ ಇದ್ರು ಶಿವಮೊಗ್ಗದಲ್ಲಿ. ಎಲ್ಲಾ ಜನರಲ್ಲಿ ಸೇರ್ತಕ್ಕಂಥವ್ರು ಅವರೆಲ್ಲ ಚಪ್ಪಾಳೆ ಹೊಡಿತಾ ಇದ್ರು, ಜೊತೆಗೆ ಕೀಕೆ ಹೊಡಿತಾ ಇದ್ರು. ನಾವೆಲ್ಲೋ ಆಡಿಯನ್ಸ್ ಅಲ್ಲಿ ವಿದ್ಯಾರ್ಥಿಗಳು ಕುತ್ಕೊಂಡ ನೋಡಿ, ಒಬ್ಬ ಅಧಿಕಾರಿ ಇಷ್ಟೊಂದು ಹೆಸರು ಗಳಿಸ್ಬೋದಾ, ನಾವು ಯಾಕೆ ಆ ಕಡೆ ಒಲವು ಆಗ್ಬಾರ್ದು, ಒಲವು ತೋರಿಸಬಾರ್ದು, ಸಿವಿಲ್ ಸರ್ವಿಸ್ ಮಾಡಬಾರ್ದು ಅಂತ ಆ ಸೀನ್ ನನ್ಗೆ ಮೋಟಿವೇಟಿಂಗ್ ಫ್ಯಾಕ್ಟರ್ ಆ ಸೀನ್ ಕೂಡ ಬಂದು. ಫಾರ್ಚುನೇಟ್ಲಿ ನಾನು ಕೇಸ್ ಮಾಡಿ ರಿಪೋರ್ಟ್ ಮಾಡ್ಕೊತಾ ಇರುವಾಗ ಡಾಕ್ಟರ್ ಜಾಮದಾರ್ ಸರ್ ಅವರೇ ಪ್ರಿನ್ಸಿಪಲ್ ಸೆಕ್ರೆಟರಿ ಇದ್ರು. ಸೊ ಈ ವಿಷಯವನ್ನು ಹಂಚ್ಕೊಂಡಾಗ ಬಹಳ ಖುಷಿ ಅನ್ನಿಸ್ತು. ಬಹುಶಃ ನಾನು ಇರ್ಲಿಕ್ಕೆ ಕಾರಣ ಎಲ್ಲೋ ಅವರೇ ಅನ್ನೋದು ನನ್ಗೆ ಬಹಳ ನನ್ನ ಆತ್ಮ ಸಂತೋಷ ಆಗ್ತಾ ಇದೆ. ಇದು ಒಂದು ರೀತಿ ಅವರ ಸ್ಪೆಷಲ್ ಲೆಕ್ಚರ್ ಜೊತೆಗೆ ಒಂದು ಗುರುವಂದನ ಕಾರ್ಯಕ್ರಮ ತರ ಕೂಡ ಆಗ್ತಾ ಇದೆ. ಸೊ ಹಾಗಾಗಿ ಸರ್ ಬಗ್ಗೆ ಇನ್ನು ಹೇಳೋದು ಬಹಳ ಇತ್ತು. ಅಂದ್ರೆ ನಮ್ಗೆ 98, 99 ಮತ್ತು 2005 ಅಲ್ಲಿ ಹೆಚ್ಚುಗಳು 200 ಜನ ತಹಸೀಲ್ದಾರ್ಸು ಅವ್ರಿಗೆಲ್ಲರಿಗೂ ಉತ್ತಮ ತರಬೇತಿನ ಕೊಟ್ರು. ಆಮೇಲೆ ಎಲ್ಲೂ ಕೂಡ ಈ ರಾಜಕಾರಣಿಗಳ ಹಿಂದೆ ಪತ್ರ ಇಟ್ಕೊಂಡು ಹೋಗ್ಲಿಕ್ಕೆ ಅವಕಾಶ ಕೊಡ್ಲಿಲ್ಲ. ಅವರು ಹೇಳಿದ್ ಒಂದೇ ಒಳ್ಳೆ ತರಬೇತಿ ಕೊಟ್ಟು, ನೀವು ಇಂಗ್ಲಿಷ್ ತಾಲೂಕ್ ಇಂಗ್ಲಿಷ್ ಸಬ್ಡಿವಿಷನ್ ಇವಾಗ ಇಂಟ್ರೆಸ್ಟೆಡ್ ಅಂತ ಹೇಳಿ ಕೇಳಿದಾಗ ಎಲ್ಲರೂ ಒಂದು ರಿಕ್ವೆಸ್ಟ್ ಪತ್ರ ಕೊಟ್ಟು, ಅಷ್ಟು ಈಗ ನಾವು ಎಲ್ಲೆಲ್ಲಿ ರಿಕ್ವೆಸ್ಟ್ ಕೊಟ್ಟಿದ್ವಿ ಅಲ್ಲಿಗೆ ಅವ್ರು ಪೋಸ್ಟಿಂಗ್ ಮಾಡ್ಕೊಟ್ಟಿದ್ದಾರೆ ಜಾಮದಾರ್ ಸಾಹೇಬ್ ಅವರು. ಅದೇ ಒಂದು ಈಗ ತಾಲೂಕಿನಲ್ಲಿ ಪೋಸ್ಟಿಂಗ್ ತಗೋಬೇಕಂದ್ರೆ ಬಹುಶಃ ಈ ಇದಕ್ಕೆ ಸೂಕ್ತ ಅಲ್ಲ ಅಂತ ನಾನು ಹೇಳುದು. ಅಷ್ಟು ಅದ್ಭುತವಾಗಿರ್ತಕ್ಕಂಥ ಒಬ್ಬ ಆಡಳಿತಾಧಿಕಾರಿ. ಬಹುಶಃ ಇಂಥ ಒಬ್ಬ ವ್ಯಕ್ತಿ ಇವತ್ತು ನಮ್ಗೆ ಸಿಕ್ಕಿರೋದು ಬಹಳ ಒಂದು ಪುಣ್ಯವೇ, ನಮ್ದು ಅದೃಷ್ಟವೇ ಸರಿ ಅಂತ ಹೇಳ್ಕೊಳ್ತೇನೆ. ಬಹುಶಃ ಅವರು ಮಾಡಿರ್ತಕ್ಕಂಥ ಕೆಲಸಗಳು 37 ವರ್ಷ ಸರ್ವಿಸ್ ಅಲ್ಲಿ ಯಾವುದೇ ಪ್ರಸ್ತಾವನೆ ಸರ್ಕಾರಕ್ಕೆ ಹೋದ್ರೆ ಯಾವುದೇ ಸರ್ಕಾರ ನೋ ಅಂದಿಲ್ಲ. ಪ್ರತಿಯೊಂದು ಅಪ್ರೂವಲ್ ಅವರ ಪ್ರಪೋಸಲ್ ಅಪ್ರೂವ್ ಮಾಡಿದ್ದಾರೆ. ಬಹುಶಃ UKPಯಲ್ಲಿ 11 ವರ್ಷ ಸೇವೆ, 5 ಜನ ಮುಖ್ಯಮಂತ್ರಿಗಳು, 4 ಸರ್ಕಾರಗಳು, ಇವರಿಗೆ ಏನು ಮಾಡಕ್ಕಾಗ್ಲಿಲ್ಲ. ಒಂದೇ ಒಂದು ದಿನ ಅತಿ ಒತ್ತಡಕ್ಕೆ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿದ್ರು. ಅದೇನೋ ಬಿಕಾಸ್ ಆಫ್ ಹೈ ಪ್ರೆಷರ್ ಆನ್ CM ಒನ್ ಡೇ ವೆರಿ ನೆಕ್ಸ್ಟ್ ಡೇ ಅವರಿಗೆ ಮತ್ತೆ ಇನ್ಸ್ಟೇಟ್ ಮಾಡಿದ್ರು. ಯಾಕಂದ್ರೆ ವರ್ಲ್ಡ್ ಬ್ಯಾಂಕ್ ಇಂದ ಬರ್ತಕ್ಕಂಥ ಫಂಡ್ ಅನ್ನ ಡಾಕ್ಟರ್ ಜಾಮದಾರ್ ಅಲ್ಲಿ ಇದ್ದೇ ಇದ್ರೆ ನಾವು ಕೊಡೋದಿಲ್ಲ ಅಂತ ಹೇಳಿ ಅವರಿಗೆ ಇದು ಬಂತು, ಎಲ್ಲಿ ವರ್ಲ್ಡ್ ಬ್ಯಾಂಕ್ ಇಂದ ಆರ್ತಿ ಒಂದು ಇದು ಬಂದ ಮೇಲೆ ಅಡ್ವೈಸ್ ಬಂದ ಮೇಲೆ ಅಗೇನ್ ವಾಸ್ ರೀಇನ್ಸ್ಟೇಟೆಡ್. ಬಟ್ ಒನ್ ಡೇ ನಾನ್ ಕೇಳಿದ ಪ್ರಕಾರ ಜಾಸ್ತಿ ಕ್ರ್ಯಾಕರಿಂಗ್ ಮಾಡಿದ್ದು ಯಾರಂದ್ರೆ ಅಡ್ವೊಕೇಟ್ಸ್ ಅಂತ ಹೇಳ್ತಾರೆ. ಅದರ್ವೈಸ್ ಯುವರ್ ಬಡ್ಡಿಂಗ್ ಅಡ್ವೊಕೇಟ್ ಡೋಂಟ್ ಮೈಂಡ್ ಏಕೆ ಇನ್ನೊಂದ್ ಬಗ್ಗೆ ನಾನು ಅಷ್ಟು ತಿಳ್ಕೊಂಡಿಲ್ಲ. ಸೊ ಒನ್ ಡೇ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿದೆ ಅಷ್ಟೇ. ಸೊ ಸರ್ ಅಷ್ಟೊಂದು ಅದ್ಭುತವಾಗಿರ್ತಕ್ಕಂಥ ವ್ಯಕ್ತಿ. ಬಹುಶಃ ಇಂಥ ಅಧಿಕಾರಿಗಳು ನನ್ನ ಒಂದು 15 ವರ್ಷ ಸೇವೆಯಲ್ಲಿ ನಾನು ಕಂಡಿಲ್ಲ. ಈಗಿನ ಸಿನಾರಿಯಲ್ಲಿ ಅಂತೇಳಿ ಬಹುಶಃ ಇಂಥ ಒಬ್ಬ ವ್ಯಕ್ತಿ ನಮ್ಮ ನಾಡಿನಲ್ಲಿ ಇದ್ರ ಅನ್ನೋದು, ಒಂದು ಇಂಥ ಒಬ್ಬ ಅಧಿಕಾರಿ ನಮ್ಮಲ್ಲಿ ಇದ್ರ ಅನ್ನೋ ಬಗ್ಗೆ ಮುಂಬರುವ ಜನಾಂಗ ಸಂಶಯ ಪಡ್ಬೋದು ಅಂದ್ರೆ ತಪ್ಪಾಗ್ಲಾರ್ದು. ಬಹುಶಃ ಜಾಮದಾರ್ ಸಾರೆ ಅವರು ಸಾಟಿ ಜಾಮದಾರ್ ಸರ್ ಮೆಥಡ್ ಜಾಮದಾರ್ ನೋ ಅದರ್ ಆಫೀಸರ್ ವಿಲ್ ಫಿಲ್ ದಟ್ ವ್ಯಾಕ್ಯೂಮ್ ಅಂತ ನಾನು ಅಂತ ಇದ್ದೀನಿ. ಬಹುಶಃ ಇಂಥ ಒಬ್ಬ ಹೆಮ್ಮೆಯ ಮಗನನ್ನ ಜನ್ಮ ನೀಡಿದ ಕನ್ನಡ ಮಾತೆ ಧನ್ಯಳು ಅಂತ ನಾನು ಹೇಳಕ್ ಇಷ್ಟಪಡ್ತಾ ಇದ್ದೀನಿ. ಸೊ ಸರ್ದವರ ಸ್ಪೀಚ್ ಇದೆ, ಸ್ಪೆಷಲ್ ಲೆಕ್ಚರ್ ಇದೆ, ಹಾಗಾಗಿ ನನ್ನ ಬ್ರೀಫ್ ಆಗಿ ನನ್ನ ಇದನ್ನ ಇಂಟ್ರಡಕ್ಷನ್ ಇಲ್ಲಿಗೆ ಕೊನೆಗೊಳಿಸಿ ತಮ್ಮೆಲ್ಲರ ಪರವಾಗಿ ಬಹುಶಃ ಆನ್ಲೈನ್ ಅಲ್ಲಿ ನಮ್ಮ ಸಾಕಷ್ಟು ಜನ ಹಿರಿಯ ಕಿರಿಯ IAS ಆಫೀಸರ್ ಕೂಡ ಜಾಯ್ನ್ ಆಗಿದ್ದಾರೆ, KS ಆಫೀಸರ್ ಜಾಯ್ನ್ ಆಗಿದ್ದಾರೆ. ಅವರು ಸೊ ಅವರು ಕೂಡ ಇದನ್ನ ವಾಚ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ನಾನು ನಿಮ್ಮೆಲ್ಲರ ಪರವಾಗಿ KSM ಪರವಾಗಿ ನಾನು ಅವರಿಗೆ ಈ ಸಣ್ಣ ಒಂದು ಇಂಟ್ರಡಕ್ಷನ್ ಇಂದ ಅವರಿಗೆ ಹೃತ್ಪೂರ್ವಕವಾದ ಒಂದು ಸ್ವಾಗತವನ್ನು ಕೊಡ್ತೇನೆ. ಸ್ವಾಗತ ಸರ್. ಅದೇ ರೀತಿ ಕಳೆದ 2-3 ತಿಂಗಳಿಂದ ನಮ್ಮ ವಿಶ್ವವಿದ್ಯಾಲಯದ ವೈಬ್ರೆನ್ಸಿ ಹೆಚ್ಚಿಸತಕ್ಕಂತ ಮತ್ತು ಪ್ರತಿಯೊಂದು ಅಭಿವೃದ್ಧಿ ಕಾರ್ಯಗಳಲ್ಲಿ ಡೈನಾಮಿಕ್ ಆಗಿ ಏಬಲ್ ಗೈಡೆನ್ಸ್ ಮತ್ತು ಅವರ ಒಂದು ಸಲಹೆಯಿಂದ ನಾವು ಒಳ್ಳೊಳ್ಳೆ ಕೆಲಸವನ್ನ ಮಾಡ್ತಾ ಇದ್ದೀವಿ. ಮತ್ತು ಸರ್ ಇಸ್ ವೆರಿ ಕೀ ಅಂಡ್ ಇನ್ಸ್ಟ್ರೂಮೆಂಟಲ್ ಇನ್ ಆರ್ಗನೈಸಿಂಗ್ ದಿಸ್ ಕೈಂಡ್ ಆಫ್ ಫಂಕ್ಷನ್. ಅವರ ಹಾನರಬಲ್ ವೈಸ್ ಚಾನ್ಸಲರ್ ಸರ್. ಸರ್ ಯು ಆರ್ ಆಲ್ಸೋ ವೆಲ್ಕಮ್ ಟು ದಿಸ್ ಫಂಕ್ಷನ್ ಸರ್. I also welcome Dean of our university, Sri G.V. Patil sir. You are welcome. ಅದೇ ರೀತಿ ಡೈರೆಕ್ಟರ್ ಅಂಡ್ ರಿಜಿಸ್ಟ್ರಾರ್ ಇವ್ಯಾಲ್ಯೂಯೇಷನ್ ಪ್ರೊಫೆಸರ್ ರತ್ನಾ ಬರಮಗೌಡ ಮೇಡಮ್ ಅವರಿಗೂ ನಾನು ಸ್ವಾಗತ ಕೊಡ್ತೇನೆ. ಅದೇ ರೀತಿ ತಾವೆಲ್ಲ ನಮ್ಮ ಟೀಚರ್ಸ್, ಯು ಆಲ್ ಲರ್ನ್ ಟೀಚರ್ಸ್, ಅಸಿಸ್ಟೆಂಟ್ ಪ್ರೊಫೆಸರ್ ಈ ಕಾರ್ಯಕ್ರಮ ಮಾಡುವ ಸಾಕಷ್ಟು ಶ್ರಮಿಸಿದರ ತಮಗೂ ನಾನು ಸ್ವಾಗತ ಕೊಡ್ತೇನೆ. ಅದೇ ರೀತಿ ಯಾರೆಲ್ಲ ಅಧಿಕಾರಿಗಳು ಮತ್ತು ನಮ್ಮ ಸಿಸ್ಟರಿನ ಜಾಯ್ನ್ ಆಗಿದ್ದಾರೆ ಅನ್ಕೊಳ್ತಾ ಅಂತ ವಿಶೇಷವಾಗಿ ಮುಂದೆ ವಿದ್ಯಾರ್ಥಿಗಳು ಯು ಆರ್ ದ ಬಡ್ಡಿಂಗ್ ಲಾ ನೋ ಅಡ್ವೊಕೇಟ್. ಸೊ ಸರ್ ಅಲ್ಲಿ ಇರ್ತಕ್ಕಂಥ ಏನ್ ಕ್ರಿಮಿನಲ್ ಇರ್ತಕ್ಕಂಥ ಸಬ್ಜೆಕ್ಟ್ ಎಕ್ಸ್ಪರ್ಟೈಸ್ ಏನಿದೆ ಇಂಥ ಕಾರ್ಯಕ್ರಮ ಮುಂದೂ ಕೂಡ ಮಾಡಿ ಆ ಪರಿಣಿತಿಯನ್ನ ಈ ಮುಂದಿನ ಜನಾಂಗಕ್ಕೆ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಲಿ ಅಂತ ನಾನು ಬಯಸುತ್ತಾ ನನ್ನ ಚಿಕ್ಕ ಸ್ವಾಗತ ಭಾಷಣವನ್ನು ಮುಗಿಸ್ತೇನೆ. ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ.
Thank you, sir. Today, it's an honor to have Dr. S.M. Jamdar, former IAS officer, who will be enlightening us on criminology, criminal justice, and law education. I now request sir to kindly take over the session. Please.
So I'll come back to it in the next one. British first felt that this kind of chaos, we cannot. Justice must be equal, punishment must be the same for the same offense. And you cannot discriminate among persons based on their caste. Offense is an offense, murder is murder, rape is rape, theft is theft. You cannot have a different punishment for different people because they belong to different castes. So they think beyond it. Then another horrible thing, so no equality, no uniformity. This was a horrible system. Then there's politics. Mukha node, bada hakare anta. ಅವನು ರಾಜನ ಮಗ one punishment, ಅವನು ಬೇರೆ ಮಗ ಮತ್ತೊಂದು punishment. It cannot go on. So eventually, it was a very, very bold decision, government of India in Parliament, the British India took a decision in 1773. Went on revising it to 1891. They continued. The first law commission was appointed in 1830. 1830, you must be knowing about it. 1834, Lord Macaulay India. And you should think with all the one who drafted the original IPC and CRPC first draft. They went through revisions thereafter, first law commission, but they were not implemented. They were completed by 1835, when I was gathering as until 1860, when they were elected into law. Indians voted against British in 1887. After that, they lost what is called Sipai Mutiny, or first qualitative of they call it. After they lost the law, they took it over, they answered, we will implement.
The criminal policy, the public policy, political science, the constitution. Are they part of criminology? I'm putting the question to you, and also to myself. If you start a school of criminal justice, which Dr. Madhav Menon wrote 2 reports, and he was a member of the Government of India Appointed Committee. One committee was Committee on Criminal Justice Policy. What should be criminal justice policy? When do you make a particular behavior of people into crime when we define it as crime. For example, just take example in 2018, just about 4 years back, they enacted a new law by amending Article Section 375 IPC rape. Most of the boys, particularly in this part of Harvard, etc., teaching girls is very common. The passport is known for it in Harvard. I don't know Hubballi what way. Today, friends, that is a crime. Stalking is a crime. Stalking means following a girl, teaching her is a crime. This is 2018 definition. Beating Toms is a crime. You are not so until that time. Okay. So who decides, on what basis you decide? Burma report. So this is where the politicians, policymakers, and the parliament have to think about what acts of individual behavior in the country deserves to be made into a crime or defined as a crime under criminal law. So this is very broad.
All of you are sitting here, only one or two of you may violate the law.
What? Under what?
The law.
Right. I don't know. Commit a crime. It's a crime. That is criminology per se. Criminology per se. Then third one comes. Criminology, as you know, I have seen the syllabus of many law universities and law colleges where criminology subject is taught not as criminology, as penology. Criminology has 15 branches of this. 15 branches of it. So one of them is criminology, second one is penology, third one is victimology. Then it goes on like that, 15 specializations. In law college, what they teach? What is punishment? What is the purpose of punishment? So you have heard about retribution theory, deterrence theory, prevention theory, and rehabilitation theory. These are all theories of punishment, not theories of crime. If you talk about theories of crime, there are 57 theories. Sociological angle, psychological, anthropological angle, and a criminal law angle. There are so many angles to one simple behavior called crime or a criminal behavior. A man or a woman who is accused of committing a crime is called accused in a legal process. The accused, if you start looking at these various perspectives, a psychologist looks differently, a sociologist looks differently, a lawyer looks at him or her differently, then what is common about it? That's criminology. But what they do with him, that's penology. And corrections, all the four objectives put together, that's penology. Anyway, now reactions to breaking of law is a criminal justice system. You can say the home department in any country or state. And incidentally, I don't know why government posted me there. Maybe because I studied criminology, they posted me as principal secretary, home department. Which are the component parts of home department? Police, yes. Entire police establishment, all types of police, including spies, commandos, civil police, reserve police, city reserve police, armed reserve police, all of them part of the police establishment as a part of home department. Second comes prosecution. Directorate of prosecution is part of home department. That's second wing. Third wing is all correctional institutions. That is what we call, you can say what is corrections. There is hardly any correction. This is a only punishment. That is prisons, remand homes. So just juvenile delinquency side a different system, but that's all part of home department, except juvenile delinquency. Now, in this, the courts are excluded, but certain aspects of court work also comes into home department. For example, including certain aspects of personal files of the judges are within our purview. Whenever the CJ suspects some judge, confidentially a reference is made to the home department to look into that and make a confidential report, which I have made about a dozen judges. I don't repeat, but this is part of home department. Whenever some judge is indulging in malpractice, like taking money or using something, it is referred to home department, including judges. There are matters like Provident Fund, LTC, STC, etc., which are dealt in the government, not in the High Court. High Court controls judicial side of it. Executive side is slightly different. So these are Home Department deals with the whole criminal justice system. That's what prompted me to go back to the university teaching. I studied earlier, but this became a applied part of that. No, this is all put in one word: reaction to the making of law. Okay. Now, if we talk about criminal policy, and if we teach criminal policy here, now I talked about Shastra. That's an ancient policy. Now it's given up. Today's policy, what we have the British left system, IPC, CRPC, Evidence Act. Now, what is this system? We have to compare it to other systems in the world. This is not the only system. Mind you, IPC is also the law in Sri Lanka, is also used in Burma, in Malaysia, in Singapore, and in Brunei. Because they were British protectorates earlier. They were ruled by British. These are the same laws. I have gone there. I have seen that. Same IPC provisions. Not even one word is different. Certain amendments have been made like India has done, but these are the same laws. Because they were ruling, they implemented the same law. Now coming back to this, just an anecdotal thing for no personal reference. I went as an exchange scholar from Florida State University, Cambridge Institute of Criminology. I was supposed to teach a trimester summer course. When I wrote IAS, I wanted to coincide, so I took this course. Go as exchange scholar, write IAS and teach and come back. So 79. So I was asked to give me this synopsis of the coursework you teach to the final year master students. So I gave. Then I said, comparative criminal justice system. Which are these 4 systems? I wrote 4. One, I wrote Indian system. Second, I wrote Anglo-Saxon in Anglo-Saxon, the British system. Third, I wrote French system. Fourth, I wrote Scandinavian. These are the 4 models and different models of criminal justice in the world. There is also tribal model. In India, also tribal model is there. If you go to northeastern states, okay, the IPC, CRPC evidence don't apply there. Anyway, now coming back, the federal department told me what is Indian about it. How is Indian system different from the British? Because British system only is developed in India. It's only British who made. Why do you want to teach it? My simple answer to him is all you people know in England. Your own people created, but they created differently. How different is it? I would like to tell you certain hard facts. In the entire England, there is no penal code. You know that? There is no single uniform penal code in England. Because there says unwritten constitution. There are a number of statutes, but no single unified code. Why did the British do it in India? They had a bitter experience, as I told earlier, Rajas, Maharajas doing all kinds of. And what is India even then? What is India today? Today, British entire population is around 5 crores 70 lakhs. Indian population is 140 crores. 25 times bigger than that. Okay. So in a country like that, you can think about the pluralism of caste, creed, color, other language, literature, variety. It's a plural society. England also is plural, but only 4. You are British, you have English, not British. You are British, English, you are Scottish, you are Welsh, and you are Irish. Maybe Gaelic. The 5 different cultures are there. And in England, the English spoken is not uniform. If you think King's English, Queen's English, the pure English, it does not exist in England itself. Are you? Okay, I wrote my IAS from there. I did my MSc from there. I did it several times. So King's English is different, maybe upper echelons of the society talk about. One more thing, very interestingly. We talked about mother of democracy is England. What democracy? What is their upper house? House of Lords. It is not elected. It is hereditary. See, we abolished hereditary kings in India, but they did not abolish in them. 640 members sitting in the upper house of England are not elected hereditary. His great-great-grandfather was there, grandfather was there, father was there, he is there, his son will be there, his great-grandson will be there. They are permanent members. It's a democracy. Think about it. We say it's the mother of democracy. It's a very interesting thing. And the lords are different. The 614 odd members, they are still royals living there. I have seen half a dozen of them personally. Okay. I lived in Bath University and Bath, Lord of Bath, I went to his estate as a tourist. Okay. Now, what is the lifestyle? You can't just compare it there. Okay. This is the kind of stuff. And we generally call our judges, my lord. Do we have lords in India? One more thing I would like to tell you. So first, they don't have uniform penal code. Second thing is, they do not have separation of judiciary from legislature. Can you imagine this? They did not have Supreme Court. They had High Court. They have Sessions Court, Court of Assizes, Magistrates Court. But they did not have Supreme Court for thousands of years. First Supreme Court of England was created only 10 years back. And that gentleman, the Chief Justice of Supreme Court in England, came to India to celebrate 160th anniversary of IPC in India. And he said, what a wonderful system we think we made, but we made differently. That is a system. I'm talking about facts only, which stand in stark contrast between what we have and what they have. So, House of Lords had a committee to hear the final appeals. That was called House of Lords Committee on Judiciary. So there were 5 of them. They were wearing those wigs and sitting like devils. 5 of them. Before them, our lawyers would go and argue. Barrister is barrister. Okay. These barristers would go and argue before them. They were not judges. They were not lawyers. Well, they might be better than them. I'm not saying they're inferior. But they were members of the parliament, upper house, and not elected, mind. Unelected hereditary sitting, but sitting as the judges, ultimate judges of House of Lords Committee on Judiciary, Supreme Court. Breaking this tradition thousands of years, they created a separate Supreme Court about 10 or 12 years back. You can put in Google and find out when Supreme Court was created in England. Okay, this is their system. So whenever you go and address the Lord outside, also you call my Lord. So all our, lawyers, just psychopathy, call every judge my Lord. He's not a Lord. Why are you calling my Lord? So some judges in the Supreme Court have objected to this. Don't call my Lord or my Lord. They're supposed very high English, my Lord. That itself is whole misnomer. How we have copied certain wrong things, I'm telling you, in criminal justice system. Now we'll come to CRP. Do they have a uniform procedure code? No. It all goes by customs, their convention. Do they have a single evidence act? No. But why do we have? Their own people created for us because of diversity here. They wanted to bring in uniform. What's the problem with this? Now you will study, you are already studying perhaps evidence act. Perhaps one of the most outstanding piece of legislation in the world in evidential law is Indian Evidence Act. So I think after having said that, I must say, it is today outdated law. I'm saying it with full confidence and responsibility. If anybody can question me, any lawyer, any judge. How? You read 3 things there basically. Admissibility. There are so many provisions, what is admissible, what is inadmissible. And the judge, the presiding judge, cannot admit what is inadmissible in evidence law. Cannot reject what is admissible. And if that happens, if the trial court judge, the lawyer is, the defense lawyer is saying something, the prosecutor says, objection, Your Honor. Then the judge has to say, objection overruled or objection sustained because of admissibility. It's a very, very restrictive. Now I'll come back to that little later. Then you read about relevancy, another chapter, big chapter. And these are bywords, and it has to be on the tip of the tongue of every practicing lawyer, which you are going to be. Soon after this, after passing. Relevancy. What is relevant? What is irrelevant? The law says that. Fixed. You cannot debate 1 inch from this or from that. You take to American courts, you go to British courts, you go to European courts. They left it to the judge. He can admit anything which is relevant to the subject. Oh, admissible and relevant. If it is relevant, then it is admissible, not always. It may be relevant, but it is not admissible. There is one more thing. For example, direct evidence. Direct evidence we generally say eyewitness, because it is a person who says, I saw it, I heard it, I touched it, I tasted it. It must be direct experience of person who is deposing before the judge or in the court. If it is not direct, not admissible. It is hearsay. Why hearsay is not admissible? I'll give you a Supreme Court case in India. There was a Father Kutenpura Supreme Court case you might have heard about. Father Kutenpura killed, he was a priest, he was a Catholic, Syrian Catholic priest who killed a woman with whom he was in long time love. She fell in love with another guy. This man got jealous and the priest killed her. After killing, he went and confessed to another man, senior priest. You know, Christian tradition requires confession. What is confession? All the crimes you go and commit, I go and tell this priest, I have committed this. And you transfer all your sins on his head, you are free. Like people in India say, you go to Ganga Nadi, take a dip, all your sins are washed away. So by Christian, by confession, you transfer your guilt to that priest who hears your confession, is what happened in this case. And whether he confessed or did not confess was a matter of fact, was a question of fact. Now, should it be forced or not? Now, this man went and told the priest, and then the priest was asked to depose before the court. He said, I will not. Why? It is my religious duty. It's my right of sanctuary, partly. So I'll not confess. I will not say anything, whether he said or did not say, whether he confessed or did not, I'll not say. The case went up to Supreme Court, and eventually he was made to confess. Tell what this man told. It's hearsay. He didn't say, I killed her. He went and told X, I told her. X is man is hearsay. How is that made a hearsay? Relevant. Telling only case laws only and acceptance. Now, why I'm saying all these things? Indian evidential law is outdated because it doesn't admit many other things. Now, take for example section 43 in that case. You take section 45. Okay, in these scientific evidence comes in these two sections. Scientific evidence, there are so many rulings on that. It is not a conclusive proof. Now I'll tell you in my own experience another case. Third week of my going in 76 to USA, in our campus, it's a big campus, 52,000 students living on the campus of Rhode State University. 52,000, it's a huge township. 6 girls in a girls' hostel were murdered. It's a very famous case. I named that, you can note in open Google and see this case. What famous case? Theodore Bundy murder trial. You can note this and see your Google, Bundy. He was a law student mind in the same university. He saw these 6 girls having nice time in a bar on Saturday evening. He was attracted by all the 6 of them. One of them I knew, Neera Leary. Okay, and he went to the hostel, broke open the door somehow. And these girls generally, they don't close the door in the hostels because the main door is closed. They were lying in 3 different, sleeping in 3 different rooms at 2 a.m. He raped 2 of them. While raping, he bit their buttock. All the 6. And he murdered them. All the 6 were murdered, raped. And there was no direct evidence at all. The man was convicted simply because his teeth marks had clearly appeared on the buttocks of 3 girls. The teeth mark, not fingerprint, were lifted, produced. This is Bundy, nobody else. And the judges convicted him and he was hanged. But it took 10 years to hang him. That's another system I talked about separately. So he was hanged based on what not hearsay, not direct evidence, but only evidence of scientific basis. Is it admissible in India? Can you convict him on buttock marks? Sometimes, somebody is killed by poisoning in the wine or something like that. And that wine is sipped by the man or woman who sips it, and her lip marks appear on the glass of the wine bottle. Is it admissible as conclusive proof? No. A leftover poison may be treated to toxicology. Now, what toxicology? So much is said because forensic science, that was also my own specialty. So, when it comes to this kind of forensic science, is nothing but a scientific application of law, application of scientific methods to the detection of law. Whether fingerprint or footprint or lip prints or teeth marks, these are all technical. And identification. You can take a small small phalangeal bone. One can say whether it's man or woman, what's the height, probable weight, and the age and the gender, sex. You can make out. That's Pearson formula is there. Okay, for all the tables are there. Piece of bone. Okay. So much evidence is there. Now you have heard about brain mapping, which is done. I've seen, I can do it on you, you're saying it as you want. Then lie detector test. Okay. Then you have truth serum. Okay. This is a simple thing. These are very strange words for you. Truth serum is nothing but sodium pentothal, a small quantity, inject it. You start behaving like funny character, start uttering, oh, I went there, I saw her, I was attracted, I followed her, I assaulted her, I raped her, I killed her. Everything comes from your own mouth. One small injection. That's your truth serum. A lie detector test, there will be 3 to 5 different detectors. They will be put on your brain or some parts of the body. They record a polygraph. Basically 3 of them. What are those 3? First one, sigma manometer is your blood pressure. Then third one is BP, the pulse rate. The third one is, the second one is BP. Third one is galvanic skin reaction. What is this? It's a simple thing. When you have committed something wrong, you feel guilty inside. When you feel guilty, this is a mind-body relationship. Your words can lie, your language may lie, that's mind. But body does not lie. Even a dead man tells a tale, that is, his body is there. We can derive so much bigger science. You can say forensic medicine, forensic chemistry, forensic biology, forensic physics, forensic botany, forensic zoology. So much knowledge is there. And the Indonesia started this year the MSc course in forensic science, and I'm going to mentor there. 3 years back, they started the criminology master's degree. Okay. Now, just as a side information, there are 32 law colleges in Maharashtra where a diploma in criminology and forensic science is issued to the law students in the criminal law specialization. That's what we call 3 months, where they will teach you all these methods which I just mentioned. Now, good news, sir. The National Forensic Science University 9th campus is sanctioned for Hubballi. It is coming up in Hubballi city. My suggestion to you, sir, they're being set up now. It's announced by Government of India, and your Mantri and MP from Hubballi, Dharwad, has already announced we are selecting a land there. So now that's a good subject for this university that is target. This is nothing but another concept from Gujarat. Okay, Gujarat Forensic Science University was established about 10 years back, and Modi was the chief minister. And when it was formed, I was one of the academic council members there. Still, I am in the advisory council. And he gave 500 crores. Beautiful campus has come up, and that is the only place where they do very reliable brain mapping. Brain mapping is very interesting in the sense they put a big helmet. 32 different parameters are recorded there. Whether you have committed a particular guilty or not.
And based on that, they will say he's the man who has committed crime. Like truth serum. And then these are techniques. I'm telling only forensic science. Now that you can do it in Hubballi in next 1 or 2 years. It requires 500 crores of equipment. But equipments are there. Some are invented in Bangalore. And that can and your future batches may be able to get some glimpses of this, and you can also go in for certificate and diploma courses in this. That's advanced thing. Now, what I'm trying to say is a reaction to the violation of law is all the criminal justice system, and system is available. So all I'm trying to say is that now coming back to Evidence Act, I mentioned CRPC. In England also there is no CRPC, no Evidence Act like we have. They have different pieces of legislation. There are so many precedents that we have and they also have, but no uniform code. So our Evidence Act controls all these admissible, so it becomes so artificial today in any criminal case in India to bring in everything. This is not admissible, this is not relevant, that's not relevant. Why it should not be? Why that freedom should not be given to the presiding judge? That is the order in America. Judge has a huge discretion. He can admit any evidence, including hearsay, if necessary. No need for only direct eyewitnesses. What is the conviction rate in India? In the 60s, it is for 65%. What is it today? 27%. That means 73% of criminals are going scot-free because of this artificiality of law. Can you not change it? Mind you, not that there is no thinking. Law Commission has already given in report after report that this should be changed. Now I'll come to IPC. You must know that IPC has created certain huge anomalies in the criminal justice system. Those of you who are professors of criminal law, and we can question me on it. What is it? Like Evidence Act, IPC is a close bracketed. Judge has not much, there is some discretion, but not much discretion. Why? What should be given as a punishment if the person is proved to have committed a crime? It's mentioned there. Imprisonment 1 to 3 years, not exceeding 6 years, not exceeding this, or fine, or both. It's all mentioned in law. This is called determinate sentencing policy. In the criminal justice system, this is called determinate sentencing policy. That is our criminal justice system. It is easier to be a judge in India because everything is in law. Whether you should give life imprisonment or you give 10 years of life, with or without rigorous work or no, that's all left here. Whether you should send him to jail, whether you should do community service or something else, you don't have discretion. So judges are not given discretion. Why? Because they did not trust Indian judges. They did not trust Indians. Indian bureaucracy, where I was part of that, also doesn't trust anybody except themselves. Same thing in judiciary. So there is no discretion. So this is determinate sentencing. Now compare it with American justice. Say American judges can sentence a person, go and work in this farm. American judge can sentence him to do community service. Now kasavadi, library kutko, I just get some order. There was this discretion available. Okay, community service is part of the sentencing, but it's not written law. This is judge's discretion. And what American judges give punishment? 150 years. What's your lifetime? 100 years maximum, or 80 years, or 75 years. 150 years imprisonment. How many times you are gone? Is it possible in India? And in America, or in England, or Europe, a judge can give hundreds of crores of compensation, particularly in diverse cases. Can Indian judge give? Can he give in crores? Can he give in lakhs? Some of the fines imposed on big fraudsters, people who guilty of corruption, etc., they are given 5,000 rupees fine. Okay. What is this? 1 cup of tea in a 5 rupee. So this kind of thing, this is ridiculous. That's why I say fixed punishments, no discretionary judge, determinate sentencing policy. Whereas in America, in Europe, in England, it is open system. The judge has the discretion to grant concurrently or
simultaneously, whatever, or separately. So judge has a discretion. Now we don't have an IPC, therefore again our system is not it. CRPC, another PC. Same thing, everything is left down there. So this is because British did not trust us. They thought we were idiots. You only do as I say, that's all. It's written in the law. You don't have that system in England. And mind you, evidence is part of the procedure, it's not separate. In America, evidence law is part of the procedural law. So also in India, but they think it is separate law anyway. So that's it. But if you take, this is all what we talk about, the British made Indian system, which they themselves don't follow, but we follow, his master's wise. Okay. And then England also has, America, Canada, Australia also have Anglo-Saxon jurisprudence. What is this? First maxim. A person until proved guilty is presumed to be innocent. Now take the French system. Exactly opposite. In recent amendments, Indian Parliament is making this. In rape cases, the man is presumed to be guilty until proved otherwise. Recent law. Only by separate law, not IPC. Okay. Now in French system, it's other way around. What is the other way around? You are proved to be guilty until you prove otherwise. That's a French inquisitorial system. Okay. Exactly opposite, because French and British were always at loggerheads. Okay, they were fighting. Whatever French do, British do opposite or otherwise. Okay. Now in the Scandinavian system, they are both. You have accessorial system. One is inquisitorial French, adversarial British, and accessorial in Scandinavia, which I saw to own eyes for 3 weeks there in court. Okay, this is a kind of system, 3 differences. But each had its own drawbacks, but worst drawbacks in India, that's the reason our criminal justice system cannot be improved. So therefore, what we do, law commission has been telling, scrap IPC, revise a new law. Amend CRPC once again after 74, it's amended. Now, one more thing you know, India, we don't have jury system. Why? The juries are unreliable. They tell lies, they take money, they side with the accused or otherwise. They also have their caste, nam jati nam dharma Muslim idre, Muslim jury idre, avon parvai martare. Christian idre, Christian martare, Hindu martare, Brahman martare, SC martare. This cannot work in jury. Mind you, in Western system, except in India, jury is part of criminal justice system. Who convicts or who acquits? Not a judge. It's a jury. Verdict of guilty, verdict of innocent is returned by the jury. Judge cannot question this. Judge's discretion is only in sentencing, and that is also not fixed. You see, Indian, you don't have jury, first of all. Secondly, you don't have any options other than what is mentioned. Thirdly, strict procedure you follow. So you read CRPC, sessions court, summary trials, sessions trial, warrants trial. Oh, so nicely step by step laid down. Very good for copying in exams. So you can pass the district all that. So that's what I'm trying to say. I stop it here because I've already spoken nearly 1 hour, little more than 1 hour, 5 minutes. So I stop it here. Maybe if there's some questions, I'll take it. All I wanted to say in summary is this: specialized law universities are teaching specialized systems, comprehensive systems. The criminal justice system or criminal law system is one of the less preferred subjects. I was going to the preferences of these 24 law universities in the country. Today there are 24 after NLSU. In these 24, maximum number of law students go in for, you know what? What is the preference of most of the NLSU or other 24 universities in the country? First preference? Corporate law. Next one is real estate law. Third one is taxation law, because they are highest paid, easily available. We can manipulate easily. Okay, then comes number eight is criminal law. Number 9 is civil law. So if I talk about criminal justice system, criminal law, do this, do that, only 1 out of 8 people take it. Other 8 take other subjects, which are lucrative. Now, one more thing, and these are boys or girls supposed to be very brilliant. Occasionally, I go and teach in NLSU and also National Law University in Delhi, the Ranveer Singh Vice Chancellor since that time. Mind you, a criminology professor has become Vice Chancellor of one of the 24 universities, that is Punjab University, Punjab Law University at Patiala, is headed by my colleague G.S. Vajpayee, who was a professor of criminology in Sagar University, who was in RCU, a member of our Board of Studies. He is now Vice Chancellor of Patiala Law University. Now, G.S. Vajpayee is still there sitting there, the last 1 year or 2 years back. Now, what I'm trying to say is that you kindly take advantage of using 3 institutions in Hubballi. One is you are single faculty law university. You are specializing in these varieties of laws, starting from corporate right up to environmental, and the 4th choice is intellectual property, IPRs. So like that, teach whatever it's on. But when it comes to criminal law, criminal justice, to an extent even civil law, kindly use a synergy that is already available in Hubballi. Number 1, one of them will be soon available. That is Forensic Science University will be located here soon. In about 2-3 years time, it will reach to maturity level. Then Dharwad, you have a mental hospital. One of the oldest, 3 oldest mental hospitals in the country. Ranchi, Delhi, and NIMS in Hyderabad are the oldest mental hospitals. Now that word is outdated. Now it's called Institute of Neurosciences, NIMHANS, Neurosciences, Mental Health and Neurosciences. Okay. So that is there. Where is it relevant to criminal justice? Disputed paternity. Is he your father? Are you not my father? You know, N.D. Tiwari case. He hired a boy. He refused, you are not my son. Son went right up to Supreme Court. Supreme Court subjected him to DNA test. And he has proved he was the father. That's available in Hubballi soon. Disputed parent. And competence to stand trial. Diminished responsibility, drunkenness, insanity. All those things are there in the thing. Then patterns of violations, criminal psychiatry, criminal psychology, they are available right next door in Harvard. So those subjects can also be taught by the professors if you have kind of collaborative arrangement with them. When you are teaching criminal subjects on this evidence, they can come and teach them. Similarly, science, the Forensic Science University and all aspects of application science and technology. For the toxicology, you see, I just give an example. There is a lady by the name Vanaja in our State Forensic Science Laboratory. Now, she developed on her own voice identification on mobiles, on various phones, and otherwise also. And there was an international conference. I sent her to Czechoslovakia for this kind of time. She came back. She's a world-class sound identification expert. On mobile, someone speaks. Someone says, she can say that she was or not. Because frequency, pitch, intonation, and the depth based on that, she can say easily. The patterns are available. Fingerprints, palm prints, all that I mentioned. So today, without eyewitness, you can prove who is guilty, whether he is guilty or not. That's kind of state. And this university can definitely use that next door available to State Forensic Science University. I think I stop here, and for any questions, I would be glad to answer if I can. Not at every question I can answer. Please go ahead. Anybody can shoot any question. I took so much here.
Sir, you mentioned about the limitations for judges. That
Limitation bar?
the judges they are not given that much discretion in terms of punishment. But if they are given a space to punish as they see fit, wouldn't it be a way for prejudices to play out, sir? And there would be unfair treatment. One punishment, one offense, one punishment would be fair
This is exactly the question I wanted to raise. I'm happy you raised that question. Now, please come. You see, murder is a crime. That's it. A person murders another person. Just example. What are the circumstances? And in India, no homicides and murders are increasing, so all rape. Now, each murder is a unique case. There are no commonalities. A label called murder under section 300 or 302. 300 is punishment, 300 is murder, 299 is homicide. You can see in criminal homicide, they have exceptions, not amounting to murder, not amounting to murder, not amounting to murder. 5, 4, 6 different exceptions are there. When it comes to murder, they say intention, mens rea, and all that, and then actors reuse, actors and actors reuse, what is this? Animus nucendi and mens rea. These three basically make up. Okay, when it comes to things. Now, if you want to prove that, how do you prove? Each murder is unique. Each set of circumstances vary. Okay, in a fit of anger, that's criminal homicide. If you do something, but fit of anger is out of what? Who provokes whom? Whether provoke is sufficient to murder is a different story. But this is, I have to go back to victimology here. You see, this is called penal couple. Penal couple has two people, a victim and his criminal. Now, the man committing crime is a criminogenesis. A man becoming his or her victimogenesis. When you put the two together, the criminogenesis plus victimogenesis, you are. Now, for example, a real case I'm taking. Just this is from the place. Who was in love with a boy and she got married. Continued to affair with other wives, having husband, in spite of having husband for 3 years. And then she continued to have nice time. Once he was caught, they reprimanded. Second time they were caught, the boy was beaten, she was beaten. Third time they caught, then they went to police. Twice it didn't go. And before the police, girl said, I would like to go with that man, and I was forced to marry into this. Now what happened? Police said, you decide. They told the parents. When the girl said, I went with him willingly, so there's no rape. So he can't be charged with rape, although they had complained about rape. And she said, I don't want to live with him, I want to go. And that boy says, I want to marry her, give her. They don't want to divorce, and yet they want to keep her, and yet don't allow the boy to have any contact with her. It continued. Eventually, they murdered the girl. Who murdered? Not known. Her husband's relative, or somebody else, a hired killer? Not known. This is a recent case. Now, how do you find the circumstances here? Whoever murdered, so assuming that he's a super killer. Now there's one set. Assuming that's a husband, it's another set. Assuming that parents, a third set. Assuming that the girl's parents, a fourth set. In each case, parents of the girl, parents of the boy, the husband, the super killer, all these. Who gave super and why? Okay, if you talk about, are they identical, all the sets? Now think yourself. I gave only one example. In each example, the girl was murdered, she became a victim. Victim of what? Who is victim? Is it wrong to love? Is it right to force into marriage? And even when she said before the police, I want to go with him, I don't want to live with him. Is it right even for the police and everybody says you live with him? So set of circumstances vary from case to case. No case is generalizable in the circumstances. So therefore there is something called circumstantial evidence, even to interpret the admissible and relevant evidence. So therefore discretion to the judge is inevitable, but it must be a speaking order. The judge must say why he gives this punishment, why this particular act is special to invite them. Now that we have in IPC only in case of death penalty. In the rarest of the rare cases, give death penalty, there the judge has to give what are the special factors to define it as rarest of the rare case, Nirbhaya case, for example. What is so rarest of the rare? Okay, now, therefore, discretion to the judge is based on these circumstances varying from case to case, which in a straight-jacketed definition like murder, Macaulay defined it, you give him life imprisonment. There's a strict issue. So therefore, circumstances in criminal law vary. Therefore, discretion is necessary. Question is whether it's unbridled discretion misused by the judge. On that, so much of debate, your question is serious. So much debate is going on in USA. In fact, the School of Criminology where I did my master's and PhD, my professor got a $10 million grant in developing sentencing guidelines for the judges. Sentencing guidelines for the judges of America, all courts. That means exactly your question. How do you develop the guidelines? They are not in the law. Law gives them freedom. Therefore, judges are very important in the American system. Most important. Okay. And therefore, this kind of my professor made it in the fact that time we didn't have computer. He got some 14,000 judgments. And it's a controlled experiment. I'll take another to explain. I don't want to digress. But question is, sentencing guidelines for judges has become necessity in those countries where judges have unbridled discretion. In India, you have least discretion. In those countries, total discretion. The question is well taken. So it's a matter of balance. Yeah, thank you. Yeah. I'm sure all of you are hungry.
Anybody? From my side?
Yeah, yeah. It's so impressive to know that law college has equal number or more number of ladies taking the law. Wonderful. Huh? Not only equality, one day the number and you will see. Yeah, please. I can't hear you, ma'am. Yeah, I will repeat what you said to. Yeah, please go ahead.
My question is with respect to jail reforms, sir. Jail reforms, sir. As you rightly mentioned that the conviction, but I'm imagining that you mentioned that every man must be put in prison until he is shown guilty. The statistics show in our country that more than 70% of the prison population is of underground prisoners. And one of the late justices, Justice Krishna Iyer, had written that there has to be wherein a reformationary approach is instilled in our prison system. How do you see that being out in the country in upcoming years?
Very interesting. I'll give you some comparative example, but your question is serious and well taken. Let me explain. What she says is, Indian jails are overcrowded. Most of them are under trials, not convicted prisoners. So what reform is required? In effect, that's her question. Am I right? Okay. Now, she's right. We have in Karnataka 105 jails in entire Karnataka. And the whole country is around 4,000 jails are there. Number varies from year to year because it starts some, close some, other thing like that. For example, in Dharwad, there was a borstal school, which is a kind of jail for young adults, which is closed down now. Now, coming back, and there's a juvenile jail also, that also is closed here in Dharwad. Now, central jails are there, district jails are there, lockups are there, and this is our system all over the country because Indian Prisons Act is uniform law. Again, uniformity, British treated uniformity. Okay. Now, your question is 75-80% of the inmates are under trials and about 20% are convicts. Now, should every accused, please remember your own language, the moment crime is committed, he is not a criminal. First, he is a suspect, then he is an accused. Until proved, he is an accused. Only after proof, either he is innocent or he is a convict. So convict population, as I said earlier, from 65 it has come down to 27%. That means 70% of the offenders go scot-free. That is our bad reflection on our police, on our prosecution, not so much with judges. Judges are small portion, but maximum is Indian police system, Indian prosecution system is simply said horrible. Okay. So they go. Now next question is, why should this 75% or 80% of under trials be incarcerated? Is it right? That's your question basically boils down to that. Now, therefore, the basic maximum judiciary is bail is the first, jail is the next. But in India, what happens is, particularly from the victim side and public side and media side, if particularly rich people, educated people, powerful people, politicians commit crimes, everybody pays for his or her blood. Arrest them, arrest them, arrest them. Don't give bail, don't give bail, don't give bail. They think that arresting, putting in the jail is punishment. It is not punishment. It is only incarceration or preventing from movement. That's all. Now, bail should be given. This is the first thing. And if you don't give bail, you must record why you are not giving bail. Supreme Court, time and again, has mentioned every trial judge must consider this question. But our subordinate judiciary is so, I would not call it wrong adjective, is so scared about the certain comments in their annual reports by the senior judges or backlash in the media. They okay, he's committed a crime, he's accused, this particular section is serious, it is not a misdemeanor. It's not a minor crime, punishable 3 years or more imprisonment, let him go to jail. So that is a mindset of the judges. So judge has a discretion, but the discretion in India, particularly subordinate judiciary, is not using that effectively in answer to the previous question. They're afraid. That is a trend. Therefore, there is no reason why we should not give bail. With reasons, you can give bail. Okay, this first question. Now, something more I would like to say. In USA, I'll give you relative figures. In entire country, you see prison statistics of last year or any year. Maximum number of prisoners, including convicts and under trials together in India, is around 4 lakhs. 4 lakhs. For a population of 140 crores. In USA, prison population varies between 25 lakhs to 30 lakhs a year, average, it changes every day. Average 25 lakh prisoners in American jails for a population of 33 crores. For a population of 33 crores, you have 27 lakh prisoners. For a population of 140 crores, you have prisoners of 4 lakhs. What does it talk about that country and this country? Same thing story there also. Okay. Their maximum number of prisoners are poor, black, Hispanics. Hispanics means the Spanish people, Spanish-speaking people from certain states are outside the country. So they are also minority. They are most suppressed there. Also blacks. So here also, so if you find out 90% of them are incapable of engaging a lawyer. Now, we have a legal aid system. We can say we have a system. But how does the system work? How much you pay a lawyer? 150 rupees, 200 rupees. It is not sufficient for his auto rickshaw. How can you go lawyer unless he is a very committed man wanting to serve a poor, etc. That kind of eccentricity. No private lawyer would take up that kind of legal aid cases. So our legal aid, Namka was there. A state legal service authority is there. There is a high court judge presiding over that. District judge is presiding the state level and below whatever levels, all the 3 levels. But how many good German lawyers are appointed and how many good lawyers take those cases legal aid? Hardly any. Why? I don't want, because you pay only 150 rupees, whereas a private man gives you 25,000 rupees or 30,000 rupees. And if you go to High Court, 1 lakh per day of appearance. If you go to Supreme Court, there are judges who charge 5 lakh per day of appearance. And as Principal Secretary in two most cantankerous departments of the state, Home and Revenue, we had some 30,000 cases pending in the courts in Revenue Department. And in Home, about 7 to 10,000 cases were pending. Some of them at Supreme Court. We had to engage on the state government side, eminent criminal lawyers like Rao and Jetmalani, things like that. And they were charging 5 lakhs per appearance, mind you. And which under trial poor fellow put in the jail for years can afford to pay 5 lakhs per day and 2-3 lakhs just to prepare the brief. And the lawyer charges you, now you are coming at 9 o'clock. Now I spent from 9 o'clock to 11 o'clock 2 hours, give me 1 lakh rupees. This is called the briefing. Then preparing documentation, give me 2 lakh rupees. 10 page ಬರ್ದಿಲ್ಲ ಎಲ್ಲ ಸೇರಿ 50 ರೂಪಾಯಿ ಆಗೋದಿಲ್ಲ ಅದಕ್ಕೆ ನೀವು ನನಗೆ 2 ಲಕ್ಷ ಕೊಡಿ. So this is I'm not saying America is better, America is even worse. The richest people and the most profitable profession in America is lawyers. But nobody likes lawyers. Most of the lady lawyers do not get married. Okay, that's because boys, find that if I marry a lawyer every day, she will file a case against me. So that's a fact of the case. I'm not joking. It will come to India also very soon, or might have already come. But anyway, lawyer couples are there. My own colleagues, 3 children have married lawyers only, a very happy family. Anyway, so that is the situation. One is the discretion not being used for the subordinate judiciary more generously. Second thing is unaffordable thing. Third thing is under trials consist of basically very poor people, illiterate people who cannot afford the legal fees. Yeah. Any other question? Yeah, tell me. Yeah.
As you said, in most of the
Come to the little bit.
Sir, as you said, in most of the countries like United States and those there, the evidence is and the criminal system is not uniform. This and Law Commission is also recommending to scrap the IPCs and CRPCs and think on the new laws. So, in the context of India, what could be the new laws, sir? Because as we already witnessed, because of the Manusmritis and those religious scriptures that is exempted the Brahmins, as you said. So, will it be, if we want to create a new system, are we going back to the Indian roots, or are we again copying the Western ideas only that we are still following, sir?
Your question is ideologically loaded, but I would say that is a problem before all of you and all of us. Do you want to go back to the throwback system of 2-3 years back, or you want to go ahead 100 years later? It is a question of choice of ideology and legal policy. Now the present dispensation says things better, past is better. They are also saying future is better because we are for development. Hey, what is this kind of development? Economic development, is it the only thing? What about cultural, educational, and other developments? So they're not worried about it. But in any case, that question is unsettled. But your first portion, I correct your question a little bit. He said, Law Commission does not say scrap IPC, scrap Evidence Act, scrap FTC. What they're saying is revise them, redraft them, make them more inclusive and update them to the present circumstances. And there was a committee to revise totally IPC, and that committee prepared the draft. It was introduced in the upper house, but then by the time it was to be taken up until the government collapsed, elections were declared, next government came which did not take up. Okay. That is a revised, more comprehensive, up-to-date modern penal code. That is what the Law Commission is talking about, and that's the correct person. Similarly, I would like to tell you, present CRPC is that of 1974. Earlier CRPC implemented, there was assessorial system, there was jury system in India. It did not work properly in serious cases, session trial cases, murder, rape, etc. There was a jury system. District judge used to keep a list of jurors and select 10 odd numbers of people. They would sit and return the verdict. But there are some ifs and buts. But system was there. All that has been scrapped in 74 for good reasons. Okay, that is Indian cultural scenario. Okay, which is certain things are totally wrong. We cannot be proud about it, but present discussion things we should be. That's a different story, matter of perception. Now, coming back here, it is not absence of these things. It is not continuance of those things. Make them modern, bring them up to date to suit the present conditions of the country. That's what they're trying to do. Not scrapping. Don't use that word scrap. Revise, update, modernize. That is the system. And they are at it. Only thing government has to take it up serious. Yeah.
Follow-up question, sir.
Yes.
My question is.
Please follow. Please follow.
Sir, as you mentioned that in USA the conviction rate is much higher. So there is privatization of jails.
What is that?
There is a privatization of jails, sir. In
Privatization?
USA.
How will I get through?
So there is a need for them to keep people inside the prison for their system to work. Do you think the same approach would work for India, considering the conviction rate is much lesser?
Yeah. Again, good questions. You are providing so many other aspects. Now, in America, there is something called plea bargaining. And in India also, CRPC was amended, have plea bargaining in the CRPC. But this CRPC plea bargaining is different from American plea bargaining. I just give example from what I saw and what I read and researched into that. I had called first time statewide conference of all the 600 prosecutors in the state. I asked him this question: why you people, prosecutors along with police officers not in practicing plea bargaining? There are so many answers. I will not repeat them. Some of them are corruption, nepotism, all sorts of things. But plea bargaining in Indian system is restricted to particular sections. You can read it. There is a separate chapter in CRPC kind to read. This was introduced. Now, how it works in America, I tell you. Why conviction rate is higher? Now, you might be knowing something more, which I just digress for a minute. In America, the police officers are not selected or appointed. They are elected. Are you aware? Elected police officers. They are called sheriffs. Only in cities, the police seat is appointed. And in many of these countries, you don't have a single police department. Can you imagine America, a country of 33 crores, has 17,000 police departments. I mean, 17,000 police departments. That each city has its own police. Each village has its own police. There is nothing called village in America. They are called SMSs. Anyway, so word village disappeared from American census in 1930. That is 90 years back. So they have a standard statistical metropolitan areas, cities and counties. A county sheriff, for example, Leon County where I lived in Florida, the sheriff was my senior criminology student. The contestant became a sheriff. Sheriff is all three in one. He is the chief of police, chief of prison and chief of prosecution. Now this sheriff tells his deputies, they are not called, that police system nowhere in the world has 17 hierarchies. Constable, head constable, SI, ASI, SI, then CPR, DYSP, additional SP, SP, DIG, IC, then ADCP, it is like that, some 16, 17 hierarchies, typically Indian phenomenon, nowhere you find this. In counties, they have only sheriff and deputy sheriff. Deputies are called assistant sheriff. In a city, they have only police chief, captain, lieutenant. These are the only three things. Even in England, they don't have those many. In fact, the word constable comes from constabulary. Constable means stable keeper. Stable keeper ಅಂದ್ರೆ ಯಾರು? ಕುದುರೆ ಕಾಯೋನು. ಕುದುರೆ ಕಾಯೋನಿಂದ ಕಾನ್ಸ್ಟೇಬಲ್ರಿ ಬಂತು. Mind you, the police that we know today did not exist in the world before 1829. How many of you know this? The police system, either in India, police system was created in 1860. But in England, it was created in 1829. Okay. And they are called Robert Peel Primes introduced this, and that was not this system. That's a very simple system. I don't go into the history. But this under trials, how they do? Now I am a deputy sheriff. I charge this fellow to bring something. I bring him. I tell him, guy, I'll charge you for first degree murder. You better confess. If you confess, I'll charge you for a third degree murder. Now I don't know how many you understand degree murders. We have section 3 and 302 there, they don't have like that. In America, there are 50 penal codes. 50 plus 1, not 1 for 35 code. 50 plus 1, 50. There are variations, the definitions of different crimes. So what we call murder here in 300 or 302 is not like simple. They are mixed homicide into murder plus murder together. So what we call extenuating conditions, attenuating conditions is put there, first degree, second degree, third degree. What you will tell the accused? You better confess to the third degree or second degree murder and you will go in 1 year. If you don't, I'll ensure that you are hanged. Now he has a choice. He cannot go scot-free. He gets punishment, but a lesser punishment. Do you plead for first degree? You charge him for first degree murder, but if he agrees for third degree murder, you charge him. And America, the word is not charge, it's an indictment. It is written as indictment, pronounced as indictment. Okay, so charge sheeting is indictment. So indict him for third degree murder, whereas actually is committed first degree murder. So you exonerate him but serious offences, so that they will charge him a lesser crime. That immediately this man goes, confesses before the court, is sentenced. That is how conviction rates are higher. Also, they use all these scientific material to produce. These is much easier, social media, WhatsApp, all that. Photography, all of you have cameras here. You can record my speech, you can give it to some spy, or you can record my photograph, you can give it to anybody, you can implicate me in anything. No, this is a photograph and all that. So that kind of thing easier in America, scientific evidence, and they're up to date on that. So one is use of scientific evidence, less reliance on eyewitness, so conviction is higher. Second is plea bargaining. In India, particularly Karnataka, hardly any case I have heard about plea bargaining. So these two combined, it's a very practical approach. This guy should be in jail. So he will be in jail, maybe for some time, but he will be in jail, he will be convicted. So the conviction rate is not a function of one cause. There are multiple causes to go into that. Yeah, have I answered you? Okay. I'm sure all of you are hungry. Okay, thank you very much. Thank you.
Thank you so much, sir, for casting light on various aspects of criminology, criminal justice, and law education. I now request Professor Dr. C. Basavaraju, Honorable Vice Chancellor, to felicitate today's resource person, Dr. S.M. Jamdar, IAS officer. Thank you, sir. Now, I request the president of today's program, Professor Dr. C. Basavaraju, Honorable Vice Chancellor, Karnataka State Law University, to kindly deliver the presidential.
So good afternoon to everyone. Our esteemed guest of today's function, a very renowned academician and also a renowned bureaucrat, Dr. S.M. Jamdar, a former IAS officer. My colleagues, Professor Ratna Baramgowda, Professor G.V. Patil, all my colleagues, my dear students, and all the invitees. I am immensely so happy for having heard. This is the first time I am hearing our Jamdar sir's lecture, and I heard about him earlier that he was a man of excellence and a man with erudition, not only in the field of bureaucracy but also in the field of academics. And that I have come to know today. Sir, almost we have taken 1 hour 45 minutes continuously deliberating upon the criminal justice system and how it works in India as well as in other countries. You have taken all of us to the comparative study of this working of criminal justice system across the globe, especially focusing upon very important countries like UK, USA, Germany, India, and so on and so forth. Despite all these systems, the different system we have across the globe, but still we have many issues which are still pertinent, which still exist in our society. We have been confronted with various issues even today, though we have high respect for the fundamental principles of criminal justice system which exist in India and the other countries. For example, in spite of the criminal justice system and different principles we are governed by, there is an inordinate delay in the dispensation of justice. We have undergone many years, and all the principles of criminal justice system, they are tested time. They are tested with the time. And in spite of that, still we have inordinate delay in the dispensation of justice. As a result of which, today, millions, according to the report given by Kiran Bedi, out of the 100% of prisoners in India, nearly 76% of the prisoners, they are all under trial prisoners in India. 76% out of the total population of the prison in India. But they are still languishing in the jail without being subjected to trial. And this is what our criminal justice system. We have various principles which are really governing all individuals, irrespective of the religion or irrespective of the status or irrespective of the economic conditions. It is true. But look at the way in which the criminal justice system is operating. A poor man for having no fault of his own, when he is remanded to the judicial custody and treat him as an under trial prisoner, the under trial prisoners are never produced before the magistrate for trial at all. They have been languishing in the trial for nearly many decades. Despite the fact that recently the Supreme Court has issued a direction to all the chief secretaries of the states, that is the trial, if the under trial prisoners, they have spent that time more than the punishment. If the punishment is imposed for them, they should be released forthwith. It is true, but still, our system is such that 73% of the population, prison population, they are under trial prisoners. If the trial is conducted, they would be released forthwith. But for the want of trial, they have been still in the various prisons. And this is how our criminal justice system is working. Look at the discretionary power exercised by the judges in these cases also. We have a plethora of decisions of the Supreme Court imposing liability on the judges to speed up the case and to take decision either to release the under trial prisoner or to make them subjected to the trial. But still, these directions are not being followed strictly in most of the courts, as a result of which we are still the prisoners, under trial prisoners, they are still in the jails. But I have to remember the decisions given by the Supreme Court and recognizing the rights of the prisoners, even the under trial prisoners, which has not been stipulated anywhere in the Constitution of India. The courts have recognized the rights of the prisoners, under trial prisoners also. What is required today is, as our Jamdar said, shall we go for the revision of the present criminal law, including the Indian Penal Code, or until the criminal law is revised, shall we go for the interpretation of the criminal law so as to suit to the poorer sections of the society who are still languishing in the jails, not for their fault, but for some other purpose. See, these are we have a fast track courts, as a result of which we have established a fast track courts in order to speed up the cases, to dispose of the cases. But still, even today, the criminal cases, they are taking not less than few years to decide. So therefore, the free legal services, what we have today, as you said, normally the junior lawyers will be appointed to argue on behalf of the trials, the under trial prisoners or the accused persons who require the free legal services. Our government is not ready to appoint the senior most counsels to defend the accused people under these free legal aid services. So we have many lacunas even today. So unless and until these lacunas are remedied, unless and until the criminal justice system principles needs to be revised, till such time, I think the fate of the accused, the fate of the under trial prisoner remain as it is. I always remember the American realism. I always remember the contribution made by Justice Frank. Justice Black, in America, they typically to assess the judges are not only just to apply the law as it is, they have more responsibility. Whenever any issues come before the judges should look into the facts in a scientific manner. There must be scientific evaluation as said by many American realists. And unless and until such kind of American realism also penetrates into Indian legal system, I think larger sections of the society today, whether they are accused or under trial prisoners or whoever may be the persons, they will not get justice. I really see that judges should be given discretionary power. Judges' power should not be fettered with the framework of law or rule of law. Because American realists say that the decision of a judge should not be depend upon the letters of law. The decision of the judge should be depending upon the facts and circumstances. When a judge in fact is given a discretionary power to decide a particular issue on the facts and circumstances of the case, then only we can expect something which is different from that of our regular system of law. So therefore, sir, you have given really a very comprehensive discourse on criminal justice system, criminology, forensic science, clubbed together, and how it operates in this system. And of course, with your discourse, we have been enriched with the knowledge of the criminology, the working of criminology system, and also how it applies to the reality. Whatever may be the laws, whatever may be the system, whether the system which exists in India or elsewhere, it should ultimately give results towards achieving justice to the vulnerable sections of the society, to the downtrodden sections of the society. The people who are unable to defend themselves should be protected from such kind of system. And I hope that our today's your lecture has really enlightened all of us in respect of the criminal system, criminal justice system, criminology, forensic science, and connecting with the constitutional dimension has really, in fact, given us a new outlook towards the criminal justice system. On behalf of the Karnataka State Law University, and on behalf of myself and on behalf of all of us, sir, I am really grateful to you and extend my heartfelt thanks to you for coming over here